Good morning, everybody. Thank you for joining us today. We are almost all in from the waiting room, so I'm going to go ahead and just get us started on our announcements to start today. The first housekeeping tip is if you could please stay muted during the Zoom, that would be appreciated. It just helps us cut down on background noise. If you would like to unmute yourself to ask a question, you're more than welcome to do that. But otherwise, the chat is the best way to ask questions, and your chat icon on your app, depending on what device you're using, might be flashing right now. I just put a message into the chat telling you how to submit questions. If we don't get to them today, or if you think of another question before next week's Q&A or a future Q&A, not next week's because we're not doing it next week. That's one of my other announcements. I'll come back to that in a second. But if we don't get to your question today, please send it to info@condolaw.net and we will add it to the list for our next Q&A. I also in the chat put a link to our YouTube channel where you can find our videos for each week's Q&A along with a list of the topics that we talked about. And sometimes we do get, questions that are repeated quite a lot. And in that case, we'll often just refer you back to the most recent Q&A video on the YouTube channel where we've talked about that topic. So please keep that in mind. As I mentioned, staying muted, your Zoom toolbar is where you find your audio button. That's also where you'll find your video button. You're welcome to be on camera or off, whatever works best for you. And another announcement that we make every week that we'd like to remind you about is that we are here to talk about general information only, not to give legal advice. So we had a couple of questions this week where folks gave us lots and lots and lots of specifics or had, 8 sub questions about their topic. And we're going to have to condense those and talk about those subjects really generally because we cannot give legal advice in this forum. So we can't specifically give you advice about how to handle something or what's allowed or what's prohibited in your documents or your specific procedure for doing a certain thing. That requires legal advice. The only person that can give you that is your association attorney. If you don't have an association attorney yet, I guess it's time for my quarterly soapbox moment on this. Get one now before you need one, because that allows you to take the time to interview 2 or 3 different law firms and make sure that you choose the one that's best suited to your association's needs and budget and sort of just general way of doing business. And that allows you to establish that relationship when there's no sense of urgency, which gives you lots of time to make an informed decision for your association, so that when something urgent does come up, you have that relationship already in place. You can call up your association attorney and they can more quickly assist you with whatever urgent thing might come up. I just can't imagine how crappy it would feel to get, served with a lawsuit where you have 20 days to respond. And in that 20 days, you also have to hire an attorney to help you navigate that process. So I think having that hiring decision made in advance is just the best way to go. So that's our reminder on that for you this week. We have been telling you guys this for a while. I'll remind you just one more time that we've moved our offices. So if you are sending us anything in the mail, make sure you're using our new address. It's in all of our email signatures. And if you get the weekly reminders about our Q&A, then you'll see that in Chelsea's email signature when she sends out that reminder. We are not going to have a Q&A next week. We usually cancel our Q&A during the week of any federal holiday. And since next Monday is Labor Day, we are going to be taking the week off. I did see a comment in the chat that the video for last week isn't up yet. And I just realized that this morning and emailed Chelsea about it. So between the two of us, we'll get that up within the next 24 hours along with the video for today's Q&A. CA Day is coming up on October 18th. We've also been reminding you about that for a little while. Katie is going to be presenting again this year, and we're going to have a booth. We would love to meet you. If you don't know what the heck I'm talking about, go to the WSCAI.org website and go to the events calendar and look up CA Day. It's an annual educational event and trade show for community associations in Washington State and all of the different types of vendors that serve them. And there is educational programming on everything from legal stuff to financial stuff to perhaps maintenance and reserve study type stuff. And it's also just a great opportunity to be able to meet people in person and kind of put faces with names or, shake the hand of somebody that you've seen 20,000 times on Zoom but have never met in person. So we hope some of you will come visit us at the booth and join us at CA Day. The last announcement is again one that we've been making for a little while now, but we do want to remind everybody that the changes to WUCIOA for those communities that are currently governed by WUCIOA took effect on July 27th of this year. Those are binding on WUCIOA communities only. However, there are some sections of WUCIOA and some changes to WUCIOA that are going to be binding on all communities starting January 1st of 2026. And we've been talking about those a lot, so this shouldn't be a surprise to you unless you're a first timer here, in which case go watch some of our, last half a dozen Q&A videos on the YouTube channel. The changes that are taking effect on January 1st of 2026 pertain to meetings and to collections and delinquency notices. So keep those things in mind as we get closer to the end of this year. We have a lot of our clients that are just choosing, in particular when it comes to the delinquency notice changes, we have a lot of clients that are just choosing to update their policies and procedures now in advance of that January 1st date, so they can kind of work out any kinks involved in that change. And I think that's a great move if your community is also able and willing to do that. Before we jump into the questions that were submitted by participants this week, we wanted to cover one other topic that we just became aware of in the last couple of days. And we just got a call from a potential client and learned that there are some folks in our industry that are telling community association boards that if you don't restate your governing documents to match WUCIOA before the January 1st, 2028 WUCIOA for all date, that you are creating liability for your association in failing to restate or update your documents. So the question that we want to cover is, will your community have liability if you don't restate your governing documents to match WUCIOA? And our answer to that question is that no. If you modify and adjust your practices to comply with the statute, you shouldn't have any risk. And there are also other things that we think matter when it comes to this conversation, including the fact that you can buy D&O insurance, which would mitigate any risk as long as your board is acting in good faith. There's nothing in the statute that says that you have to amend your governing documents. There are 10,000 community associations in Washington state. And I serve on the Legislative Action Committee. I have been involved and in rooms with legislators talking about these legislative changes for the last 2 or 3 years. They are also aware of the fact that there are more than 10,000 community associations in Washington state. And the legislature did not intend that 10,000 community associations would have to go out and rewrite their governing documents. And if they did intend that, they would have put it right in the statute. And we were talking with Ken ahead of time today before, we always do like a little prep before the Q&A. And he commented that if the average cost of restating governing documents was only $5,000 per association, that if 10,000 plus community associations had to go out and spend that kind of money, we would be looking at a $50 million expenditure plus. And that's based on a real conservative estimate of the cost of restating documents, which is generally not as low as $5,000. So there are other things in the statute that suggest that the legislature did not intend for or was aware of the fact that the statute would end up being in conflict with underlying governing documents that were written before WUCIOA for all takes effect, including there's a savings clause in RCW 6490-455, which says that even if you don't follow proper procedures, association actions are still valid unless they're overruled by a court. And owners have 90 days to challenge an association action, 90 days from the date they're notified of that action. So for example, if the board makes a decision in a board meeting that was not compliant with the WUCIOA meetings provisions, but they sent out the meeting minutes from that meeting to the unit owners in that community, even their failure to comply with statutory requirements and procedures does not invalidate an otherwise valid board decision if notice of the decision is mailed to the owners and more than 90 days passes and the owners don't challenge it in court. So I think the fact that there is something built into the statute that helps associations continue to be able to function even when they make mistakes is further evidence of the fact that the legislature did not intend for everybody to have to restate their documents. Now, my message here is not that you shouldn't update your documents, because we think most communities would actually benefit from updating their documents for a million reasons, starting with the fact that most documents are really poorly written. A lot of them are very old. A lot of them contain references to the declarant, which are no longer relevant for most communities. And on top of that, there are a lot of permissive sections or items under WUCIOA that you can only take advantage of if you do amend your declaration. So some examples of those things include the ability to shift an insurance deductible when there's a damage event caused by a certain unit. Another example is high-risk component inspections and replacement requirements, provisions around short-term rentals, maintenance requirements, etc. So there are all kinds of things within WUCIOA that you can only take advantage of if you amend your declaration. And so we do think that amending or restating declarations is a really great idea for many, if not most, communities. But we also don't want to create a sense of panic unnecessarily within the industry that if your documents are not restated by January 1st, 2028, the sky is going to start falling and you're going to be exposed to some significant risk of liability if you don't update your documents. And the reality is that as long as you update your practices so that they're consistent with the new statute by that time, your risk of liability should be quite low. And that means what you can do is you can look at your documents, you can look at your budget, you can talk with your association attorney about the cost of doing a restatement, and you can budget for and do that restatement on a timeline that makes sense for your community instead of sort of panicking and rushing to that because of an unfounded concern for liability. Jennifer, did you have anything you wanted to add to that before I jump us into our questions?
I don't think so. I think you covered it.
Okay, great. Thanks. All right, here's our first question from participants for this week. Could a board hire someone to photograph a resident's home in an HOA without notifying them? The short answer to this question is probably yeah. There is no reasonable expectation of privacy for areas that are open to view from publicly accessible areas like sidewalks, streets, and that's true even in a gated or secured community. So it might be reasonable to hire somebody to photograph conditions within the community, violations of the CCNRs, or as for evidence to support fines or enforcement. We have communities that do this using drones even, which fly through the community and take video for the purposes of documenting violations, both violations of the governing documents generally, as well as ARC-related, architectural-related violations. We also definitely know of many communities where board members or managers take photos for enforcement purposes when somebody's in violation of the governing documents. And hiring a photographer to do that for you doesn't change the analysis of whether it's permitted. So our general answer is that this is probably fine. We would obviously need to get to know more specifics about the circumstances in order to give advice to a client on a particular situation. But this is the general answer to this question. Jen, did you have anything you wanted to add?
No, you covered it. So our next question is, how can a board member be removed? A person became a board member initially by board appointment due to a midterm vacancy. Subsequently, the person remained on the board by attrition. In other words, the party did not win an election. A vacant spot was filled. What's the recourse then to have this member removed? So the actual question is too specific to answer because we don't know your governing documents. We don't know the particular situation with how this individual remained on the board without being elected. So we can't answer your question. The how this works is different for different communities because how a board member is removed is generally in your bylaws. So, in general, the only way to remove a board member entirely is to hold a meeting of the owners called for that purpose and allow the owners to try and vote them out. Board members, in just overall, once a member is appointed or elected to the board, they're a board member. They don't have to be elected to have the full authority to act as a board member. Being appointed versus elected does not affect their authority. And in our experience, the most attempts to remove board members fail because it requires a supermajority of all owners to vote to remove a particular person. So WUCIOA has a removal process. Most bylaws have provisions as well. So the HOA Act standard you can find in 6438-025 sub 5, which is the owners by majority vote of the voting power in the association present in person or by proxy and entitled to vote at any meeting of the owners in which quorum is present may remove any member of the board with or without cause. So how this, as I said before, how this works is that the board or a group of owners, usually I don't remember what the statutory requirement is off the top of my head. Generally, it's either 10 or 20% of owners to call a special meeting. At that meeting, the topic on the agenda that has to go out with the meeting notice is removal of that particular board member. At that meeting, you must have quorum, but even beyond quorum, you're required to have a majority of all owners, not just those present at the meeting, but all owners vote to remove that particular person. So it's a very high bar. As I said before, most attempts fail. The easiest way to get someone off the board is to wait for their seat to come up for election and then try to get someone elected in their place. Valerie, did you have anything to add to that?
Yeah, the only other thing that I will remind everybody is that our governing statutes all have meeting and notice requirements, and you have to comply with the notice requirements for this type of meeting, just like you would for any other. And the removal of a board member has to be specifically called out on the agenda, and the board member has to be given an opportunity to speak to the owners before that vote is taken. So again, these are all really general answers to this question. Your specific community might have more specific requirements in your governing documents, like Jen mentioned at the very beginning. So keep in mind that this is not the answer for any one community. It's just a general answer. Each community might have, quirks in their documents that we can't know about in this venue. Our next question is this: what is the best practice for handling board member resignations? There's a whole lot of sub questions here, including things like, do we have to announce it at the board meeting, include it in the minutes? Does the letter have to be read out loud? Is the letter considered a personnel record? When does the resignation become effective? I'm not going to read through every single one of those questions because I do think the specificity of the questions suggests that you might actually be dealing with this in your community. And so I want to point you to your association attorney, where you should copy and paste the question that you sent to us and send that to them so they can give you specific advice on this situation. I will say that typically board member resignations are effective on the date that's indicated in the letter of resignation, or on the date the letter is received if no date is otherwise indicated in the letter. And if a board member resigns in a meeting, that would be reflected in the meeting minutes. If they resign by a letter and they're not at a meeting, then certainly you should at least make a note of that at the next board meeting and include a line item about that in those meeting minutes. Typically, a resignation is a unilateral action by a board member, and it doesn't have to be accepted by the board in order to be valid. So if I resign from the board, I get to resign from the board. You don't get to tell me, nope, we don't accept that, right? The acceptance is not the dispositive thing. It's my resignation that controls, I guess. If a board wants to allow a former board member to withdraw their resignation, you can simply reappoint them to fill the vacant position at your next board meeting and indicate that that's happened in the board meeting minutes. Resignation, like I said, should be announced at the next scheduled board meeting. You should discuss appointing someone to fill the empty position until you have an election, or you could choose to just call a mid-year election if you want to do it by election versus by appointment. The resignation letter is a record of the association, but I want to clarify that board members are not personnel of the association. They are not employees. So it's not a personnel record. It's just a record of the association and should be kept in accordance with whatever your records retention policy is. And if you don't have one of those, then look to your governing statute and the records section within it to guide you as to how long to keep that a copy of that letter. So I think that covers it about as generally as we can. And Jen, if you have anything to add, please do.
Nope, I think you got it. So our next question is, does the board need to respond to questions about financials before the next board meeting? I have some concerns about the numbers and want answers before the next meeting in a few months. What if the budget states the dues are higher than what is collected from owners? The board only meets quarterly and the financials are not sent ahead of the meeting, so the board meeting runs out of time for the owners to ask questions. Can we ask for more time for the next board meeting due to the concerns of financials that are not being addressed? So part of this question is, again, too specific because we don't know what statute you're under. We don't know your governing documents. So under RCW 6490, 495 sub 1, and then subsections A, E, and H, all owners have the right to review association financial records, including budgets, records of receipts, expenditures, statements, etc. This language has also been added to all prior community association statutes. So it's in 6432, 6434, and 6438. So, but nothing in the statutes requires the board to answer questions raised by owners regarding financials or anything else. Now, we recommend that the board or management company, depending on if you have one, answer reasonable questions, but they're not required to. So if this is a question from an owner, you can ask that the association manager, if there is one, or treasurer would be willing to meet and discuss the financials with you and answer questions. You can also submit questions to the board for their response. Just also overall, board meetings are for the board to conduct business. They are not for owners to ask questions. So 6490, which doesn't, the meeting requirement regarding owner forum doesn't take effect until January 1st of 26. But the owner forum is for the owners to posit questions to the board for answer later or bring up a topic that they want the board to be aware of. The board meetings are for the board to conduct the business of the association. So, as I said, in January, owners are allowed to make comments to the board at the beginning of board meetings. It doesn't require the board to answer questions or respond to those comments. The prior community statutes, as well as 6432, 6434, and 6438, also require audits by outside CPAs if your community qualifies to have an annual audit and it has not been waived. If your community qualifies for that, you can look at the audits to see if that answers your questions. And then honestly, if your board is only meeting once every several months, so quarterly or semi-annually, you could also request that they meet more frequently. Most communities currently do some sort of, most boards do some action communication between meetings via unanimous consent. That will no longer be an option starting January 1st, 2026. More frequent board meetings may be necessary for communities to continue to function and make timely decisions once that change comes into effect. Valerie, did you have anything to add to that?
Yeah, I just want to clarify the reason for the last thing that Jennifer said is that under WUCIOA, this has been true since 2018 when WUCIOA was enacted. Board decisions are required to be made at open board meetings. And come January 1, 2026, that provision will be applicable to everybody, regardless of what your governing statute is. which means that if your board has been making decisions outside of board meetings, like via unanimous written consent, they will no longer be allowed to do that under the statutes unless the decisions are ministerial only or are essentially confirming a decision they made in an open board meeting, right? So if your board is currently doing things like approving expenditures and, voting on attorney recommendations for delinquency files and any sort of substantive decisions in between board meetings by email, that option will no longer be available to them starting in January of next year. So a lot of our communities that currently only have quarterly or semi-annual board meetings are going to need to look at more frequent board meetings. Otherwise, business and decisions are going to grind to a halt in between those board meetings. All right, next question. I have a question about RCW 649525. This is the budget ratification section of WUCIOA, which is applicable to everybody in Washington. Will you please clarify if the meeting date for the budget ratification meeting needs to be set 14 to 50 days from the date the budget is adopted by the board, or from the date the notices are sent with the adopted budget, which can be up to 30 days after the board adopts the budget, the proposed budget? The short answer to this question is that the meeting date is set for between 14 and 50 days from when the budget ratification meeting notice and packet are sent out to the ownership. So when you put that budget ratification meeting packet in the mail to the ownership, that's what starts the clock ticking on that 14 to 50 day notification window during which your budget ratification meeting has to take place. I'm going to again point you to the statute, which is RCW 6490-525. It's actually a pretty short statute. So if you just Google that and read it, you should be able to parse that out pretty quickly, I think. But what it requires is that within 30 days after the board adopts a proposed budget, they have to mail it out to the ownership with a whole ratification packet. And within 14 to 50 days of that mailing, you have to have the ratification meeting. So I hope
And I
that
put the statute, I put the statute in the chat.
Oh, perfect. Thanks, Jen. I think that covers that. So you can carry us into the next question.
Okay, so the next question, are there current regulations that state if a condo board of directors member is behind on their financial assessments obligations that they cannot serve on the board of directors? So check your governing documents. There is no such prohibition or statute. So if there's nothing in the governing documents regarding an individual having to be current on assessments, the answer is no. You can't add a restriction on who can serve on the board without it being in the bylaws or in the governing documents. So now, this next statement is only applicable to current WUCIOA communities. So WUCIOA allows the board to remove a delinquent board member if they are delinquent more than 60 days and fail to cure the delinquency within 30 days of being given notice of the delinquency. And that is 6490-520 sub 4. So what this means is that if you are a WUCIOA community, the board can vote to remove a member who is at least 60 days delinquent, but they have to be given notice of that delinquency and give 30 days to correct it. But also remember that the board member who is being voted on being removed also gets to vote on that particular issue. So for any community except one who is either formed after July 1st of 2018 or has amended their documents to adopt WUCIOA, the answer is if it's not in your governing documents, no. For WUCIOA communities, the answer is probably, but there's a process to go through, and please contact your association attorney before you start. Valerie, did you have anything to add with that?
Nope, that's it. Our next question is about electronic voting systems. It says, these are becoming more common, and I recently received a request to vote from CAI using Election Buddy. What requirements would this type of voting system need to meet in order to satisfy WUCIOA restrictions or guidelines? So the section of WUCIOA that you're going to want to look at here is RCW 6490-455. And you can always find each of our governing statutes has a clear voting section. So if you Google whatever your governing statute is, whether it's WUCIOA or otherwise, if you Google RCW 6490 or 34 or whatever, and then the word voting, it'll take you to the section of your governing statute that deals with voting procedures. Some quick requirements would include the ability to keep ballots for at least a year, the ability to track votes by percentage if it's applicable. So if you're in a single family home HOA where all the votes are weighted equally, that's less of an issue. But if you're in a condominium that has different percentage allocations for voting purposes, the software has to be able to calculate each vote as it is required to be weighted in your declaration by those percentages. And it has to have procedures that allow for confidential ballots, which is a new requirement under the WUCIOA voting procedures. Some of the language from the statute includes the following. The association shall implement reasonable measures to verify that each ballot in a tangible medium and electronic ballot is cast by the unit owner having a right to do so. So that just means you have to be able to verify that the person who is submitting the electronic vote is actually the person who's entitled to vote. I don't know that there is a really high bar for how you verify that. If you've been communicating with an owner by email at a particular email address for a long period of time, and that's the email address they use to cast their vote via the voting software, then that might be good enough. But you do have this requirement to make sure that the person voting is the person who has the right to vote. Subsection M of the voting section also says that an association that allows electronic ballots shall create a record of electronic votes capable of retention, retrieval, and review. So whatever voting software or electronic voting method that you use, it has to result in a record of your electronic votes that you can retain, that you can access, and that you can review. So I would suggest that whatever form that record takes, you save a PDF of it in the association's records, rather than relying on, for example, being able to access it by logging into that voting software website, because websites come and go sometimes. They don't all last forever. So anyways, you can learn more about the requirements by looking at the statute 6490-455, but that covers some of the highlights. Jen, did you have anything to add?
I don't think so. And we might have time for some questions at the end. So if you have a question or want clarification, please feel free to put that in the chat. So our next question that we prepared ahead of time. In Washington, can an association charge a flat admin fee when owners don't submit required tenant vehicle lease information by a deadline? Or should that be enforced only via the existing violation fine schedule with due process steps? So the way this question is worded was interesting to us because what you're calling an admin fee seems to be a fine by another name. So it's a fine. Someone is not complying with the governing documents. So as such, you have to follow your enforcement procedures and allow due process before levying the fine. So the way is this fee used to help pay for the administrative cost of trying to chase down the owner to get the information? Is this fee levied once or multiple times? But if you just in general trying to call a fee by another name, trying to call a fine a fee doesn't work. And someone saying this is an administrative fee for not giving this information, and the owner challenges it and goes to court, it's not an argument I would want to make to a judge. that this is an admin fee, not a fine. So when it comes to assessing costs to owners, the rule of thumb and the best practice is to give due process. That way, if the owner challenges it and it goes to court, you show that you followed proper procedure and it's more likely that a court would uphold it. Valerie, do you have anything to add to that?
Nope, I think you covered it. The next question is, do you recommend that board members sign a confidentiality agreement? If so, how would enforcement work? The short answer to this question is that no, we do not recommend that board members be required to sign a confidentiality agreement, especially when it comes to normal routine issues related to governance. And I think the second part of your question, how would enforcement work, is part of why this is our answer, right? Enforcement of things like this is difficult. And we want to remind everybody that nothing that you sign, whether it's a confidentiality agreement, a board member code of conduct, none of that supersedes or takes the place of statutory requirements for board members to exercise reasonable care to protect information, and board member the duty of care that the board members owe to the association. So if a board member violated confidentiality, either that required by the statute or by an agreement, there are possible enforcement methods, but none of these, it's all sort of like trying to put the cat back in the bag, right? One is that you could remove the board member from their role as an officer. That's a board vote thing. So if this was the board president, the board can vote to strip the president of their officer position. But you can't take them off the board entirely without a vote of the entire ownership, like we mentioned earlier. The only exception or scenario that we can think of that might warrant a confidentiality agreement of some kind is that if the association is involved in litigation or some negotiation process, there might be for example, a settlement agreement, a confidentiality clause. But that again would be something where a board member is signing that settlement agreement on behalf of the association, as opposed to individual board members signing a confidentiality agreement just because they're serving on the board. If you want to look at RCW 24.03A.495, that's a provision in the nonprofit corporation statute that references the obligations of confidentiality that are imposed by law, but it's not terribly specific. And again, just boiling it down to the short answer, we do not recommend that board members sign a confidentiality agreement. And in fact, I just thought of this now. I didn't even think of this before when we were doing our prep and our discussion ahead of time. One of the things that the legislature is beating the drum of, and that we have always been very big proponents of, is transparency with your ownership. And a confidentiality agreement runs directly afoul of the general value of transparency. Board business is supposed to be transparent to the ownership. Owners have the right to sit in on board meetings. And if you are not in an open meeting community yet, you will be soon, starting January 1 of 2026. They have the right to look at board meeting minutes. They have the right to request association records. So I'm not sure what the purpose of a confidentiality agreement would be, or what the purpose of having a board member sign one would be, outside of, like I said, the very narrow exception, which would be there's a settlement agreement that the association is a party to, and that could potentially have a confidentiality clause, but that would be very, very limited to the circumstances of the settlement. So Jennifer, you can feel free to add anything that you have to add on that one, or take us to our next question.
Well, the only thing I would add is that if something is being discussed in executive session, and statute is very clear on what is considered executive session business, that should be kept confidential to the board. If someone is violating the confidentiality of executive session, that's a different thing, but you don't need a confidentiality agreement for that. And the ability for the board to enforce any sort of confidentiality agreement or just enforce against a board member for discussing things that they shouldn't. You can strip them of their officer position if they have one, but you can't remove them from the board without ownership approval. And it's a supermajority. We've already discussed that earlier in this Q&A. So you're limited on your options. Did you have anything else with that, Valerie? Okay. So the last question we prepared ahead of time, so please feel free to either message Chelsea or put them in the chat. So the last question is, based on changes, we're revising our agenda template for board meetings. We put out the board meeting calendar the year prior. We are updating the standard agenda, moving the forum, owners forum, to the beginning of the meeting as suggested by our attorney. For the agenda at the meeting, do we need to print the agenda that we have created with all invoices and provide copies? Because we have a standing agenda, we have not routinely passed out the actual agenda. It gets published as minutes. Should we be including all invoices with the published minutes? And then if there's a Q&A on this with specifics, let me know. We hold our meetings at the clubhouse in person, not via Zoom or other electronic forum. I want to get this process down so we can be consistent going forward. So the answer, or just a short answer, is see RCW 6490-455 subsection 2G. So in a nutshell, that provision states if board members are given copies of the actual agenda, oh, that's my translation, sorry. If board members are given copies of the actual agenda for review, they must be made reasonably available for owners to view as well. And the two exceptions are unapproved minutes and materials used in executive session. Paid invoices are an association record. There is no privacy or reason why an owner should not be able to see them, but they are not part of the agenda. Invoices are records that owners may request and must be made available if if requested. It may make sense for you to publish invoices to a folder on the association's portal if you have one, on the web page, and honestly, it's likely that most owners won't look at them anyway, but the agenda is not the board packet. So if there's a packet of information provided to the board in advance of the meeting for them to review so they're able to ask the questions that they want to ask, they're informed and can vote on the issues that are on the agenda, that packet must be made available for owners to view. Invoices are an association record. They're not part of the agenda. So I think I've covered that one. Valerie, did you have anything to add?
I don't, and I think we can just go ahead and jump to some of the questions in the chat. I'm going to start with a question that I'm not sure I fully understand, but I think we can at least speak to this generally, which is, can the board make a decision on an insurance claim instead of the homeowners voting for it? And what I'm going to start by saying the thing we say ad nauseum, which is not advice for your specific situation. I can't answer this question for any specific association. Typically, the board is vested with the authority to make decisions on, so that generally would include decisions about claim or not. Implications. So as insurance coverage for that damage, or this insurance does not mean that you can transfer the cost to a unit owner, right? So there are sort of complexities and lots of moving parts when it comes to decisions about insurance claims and coverage. So I would recommend that any board trying to decide if they want to file a claim for a certain event, to have an association attorney that they can contact, tell them what the situation is, and ask whether it's reasonable not to file a claim. And then also ask, if we don't file a claim, how do we have to handle the cost related to this damage event? Jen, did you have anything else you would want to add on that one?
Yeah, and insurance and responsibility for damage can be two different things depending on the language in your governing documents. So if you have a question on who's responsible for what in regards to damage, contact your association attorney. And as Valerie said earlier, if you don't have an association attorney, feel free to find one. Please find one to answer this question because we get a lot of questions from clients, potential clients. We have this particular issue, and Valerie sees this all the time on the collection side when an association assess costs of damage to an owner that doesn't have authority for that assessment in the governing documents. So don't make an assumption, contact an attorney because the responsibility for damage and insurance is very specific to your governing documents.
Great. Thanks, Jen. I'm also going to go ahead and put a link into the chat right now, which is to the WSCAI Business Partner Directory. And if you search by attorney or lawyer, you will see a number of law firms, many law firms that are that practice in this area that would be great association law firms for you to consider interviewing as you are trying to hire an attorney for your community. We have several more questions in the chat, so we're going to move on to that one move on from that one for now. We're not going to come back to it. The next question in the chat is, are notice definitions or provisions changing? And if owners opt in for email communication, we can send notices to them in that manner, correct? And all others would need to be snail mailed. Is that correct? Jen, do you want to take that one?
Okay, so notice the definition of what is required for notice has not changed. How notice is provided has changed because the legislature amended the statutes. What was it, Val, in 21?
Yes.
Because of the COVID crisis. So notices required to be given under your governing documents, notices of delinquency, notices of violation, meeting notices, formal notice. Those are formal notice. And statute requires that they be sent either via mail or if owners have opted into receiving electronic notice, email. And then there's provisions regarding how notice is provided via email. So if an owner has opted in, and that opt-in has to be in the form of a record that can be distilled into paper. So a text probably wouldn't qualify. But an email saying, yeah, I want to receive notices via email, that's fine. You can distill that into paper. So an owner would have to email you saying, yes, I want to receive electronic notice. We have had clients have us draft a form for owners to check a box saying that they want to receive electronic notice. I think several management companies have a certain section on the portal where you check a box saying that you want to receive electronic notice. As long as that is able to be distilled into paper and the owner has to do something stating that they want to receive electronic notices, that's fine. So yes, then electronic notice, you send all notices via electronic, via email or other electronic means. Statute has changed with regard to delinquency notices.
Yeah, I can
So
on that one if you want me to.
yeah, it makes more sense if you cover that as well.
Yeah. So even for an owner who has opted in to receiving electronic notice, the pre-foreclosure notices of delinquency have to be sent by snail mail. And the initial notice of delinquency that is newly required in January of 2026 must also be sent by snail mail. And there are additional notice requirements with respect to that delinquency notice. It has to be mailed both to their address within the community, so the lot or the unit within the community, and to their offsite mailing address if they have given you one, which means that if they've given you an offsite mailing address and you know that they don't live in the community, you still have to send that initial delinquency notice to their address within the community, even if you know they don't live there. And also that initial notice of delinquency that we're talking about, the new one the requirement goes into effect in January of next year. You also have to email it to them if you know their email address, even if they have not opted in to receiving electronic notice. So that first notice of delinquency to an owner that has to be sent within 30 days of their account becoming delinquent, you have to mail it to their unit or lot address within the community. You have to mail it to their offsite mailing address if they've given you one. And you have to email them a copy if you have their email address, even if they haven't opted in to receiving electronic notice. So Jennifer's answer is all correct for the vast majority of association notices. If you're sending out, notice of an annual meeting, if you're sending out a budget ratification notice, if you're sending out notice of, I don't know, fire sprinkler inspections or a social calendar thing that's happening, in the fall or whatever, those can all be sent in the manner that Jennifer covered. Email if people have opted in, snail mail otherwise. But there are certain notices, and the delinquency notices are one of them, that have to be mailed or sent in very specific ways that are not the general notice provisions. And the other thing I want to cover is, so part of your question was whether notice definitions or provisions are changing. The answer to that is no, outside of what I just covered with the delinquency notices. So if you need to refresh your memory on how to give adequate notice, Google your governing statute, RCW 6490 if you're WUCIOA, 6434 if you're a new act condo, 6432 if you're an old act condo, and 6438 if you're governed by the HOA Act. Google that plus the word notices, and it will show you the subsection of your governing statute that pertains to notices, and you can actually just read the statute and see what it says when it comes to giving notice. We've got a couple more questions in the chat, so I want to move us on to the next one. Do you know if there's any activity to revisit the WUCIOA audit provision to allow owners to vote on whether to have an audit or not? Obviously, this applies to COAs with budgets greater than $50,000. Jen, do you happen to can you look up the WUCIOA audit section really quickly just to pop the section in the chat while I answer the question? There is no indication at this point that the legislature is going to revisit the current WUCIOA audit provision as it exists right now. That may change in the future, but I serve on the Legislative Action Committee, and that is not one of the provisions that I've heard chatter about changing in the very near future. So Jennifer will pop the audit section into the chat just so you guys can all look at it and see what it says. And when we hear otherwise that changes might be coming down the pike, we'll certainly let you guys know. But right now that isn't the case as far as I know.
And there was another question later in the chat regarding audits. I thought we'd just cover that really quick as well. Oh, and they put the statute 649530. So when it comes to the audit requirements, 6438 and 6434, which is also applicable to 6432. So all community associations are required to have an annual audit. 6438 and 6434-32 have provisions that allow a community to waive the annual audit, either for condos less than 50 units, for HOAs less than $50,000 assessments. When WUCIOA for All comes into effect, everyone is required to have an annual audit if you have assessments greater than $50,000. There is no ability to waive that. So if you are an HOA or under WUCIOA right now, if you have assessments over $50,000, you are required to have an annual audit. Whether or not you choose to follow the statute is up to you, but we highly recommend that you do that. And if you don't, there may be, I don't know that there's really any benefit to not doing an audit. The statute requires it. you need to do it.
And I think that, the sort of follow-up question essentially is, are you creating liability for the association if you fail to get an audit? And my answer to that question is, if you are refusing or failing to comply with a very clear statutory requirement, that always exposes an association to liability, which is why we do not recommend that you do so. We have another question in the chat unrelated to audits. I think we covered both of the questions that are audit related. So somebody pop something into the chat if we missed anything that you wanted us to talk about. The next question is, does the opportunity to be heard require a meeting, or can it be done by email? And my answer to this question is that it requires a meeting. I'm curious if Jennifer has a different answer to this, if we think this can be accomplished in a different manner.
I honestly don't think it can. Now, please know that there's no statutory or court guidance on what opportunity to be heard means, other than it has to be reasonable and an actual opportunity for the owner to be heard by the body deciding whether or not a violation has occurred. So, is it possible to do it via email?
Maybe
That's not an argument I would want to make in court.
And maybe here's what I guess as you were answering, I was like running through scenarios in my mind. Let's say we're not even talking about a violation fine, but we're talking about assessing costs to the unit, and these costs can't be assessed until an owner has been given a due process notification, which, by the way, is going to be the case for everybody once WUCIOA for all takes effect in January of 2028. Even if you have an insurance amendment that very clearly says you can assess certain types of costs to the unit, come January 1, 2028, you will only be able to do that after giving the owner notice and an opportunity to be heard about those costs. And let's say that owner is deployed overseas or living overseas for a year, and they can't attend a meeting, and they ask you, can we conduct this hearing via email? I think that in a scenario like that, I could make a reasonable argument to a court that the owner is the one who asked for the email hearing, and that the association agreed in order to comply because it was, a location-based restriction or whatever for the owner. Maybe they're unable to participate by Zoom or whatever. But I think most of the arguments that we might have made in the past about how email could qualify or could replace a meeting they don't work as effectively anymore, given the fact that we can do all of these things virtually now. So I think that for the most part, opportunity to be heard requires an actual meeting. That being said, it does not have to be in person. It can be virtual. And as long as the owner is given an opportunity to be heard by either the board or the hearing board, if it's different than the board of directors, that's what we're looking for in terms of statutory compliance. What are your thoughts on that, Jen?
Honestly, I agree. It's really dependent on the situation. If you have a question where you think, well, can we do this via email rather than via meeting, contact your association attorney for guidance, because it can be very fact specific. Because as Valerie said, there are reasons why it's reasonable to not hold a meeting. But generally, for the vast majority of circumstances, just hold the meeting.
Thanks, Jen. That brings us to the end of our questions. And I guess I'd like to just end with a quick reminder that this Q&A is a forum for people to ask general questions that are broadly applicable for community associations in Washington State. We do not do this as a marketing tool or to sell our firm or our services. And so questions that are of that nature just are not going to get answered in this Q&A. So I just want to remind everybody of that. I want to thank you all for joining us, and we will look forward to seeing you next time, but not next week, because we are not doing the Q&A next week. Bye, everybody. Have a good one.